T-shirt, that's what you got. That's what you got, a T-shirt.
So,
You're looking at a total of 30 years in prison, right?
so
And you think your life's future,
A courtroom hearing takes a sharp turn when a man accused in multiple felony cases tests positive for cocaine while out on bond before Judge John Stevens. The defense insists the result may have come from medication given during jail incarceration and points to later clean drug tests as proof. But Judge John Stevens warns that accepting that explanation without proof could open the door for every future defendant to blame the jail after failing a drug test. Now the court must decide whether this was a medical misunderstanding or a serious violation that sends him straight back to jail.
like that's your best foot forward, a T-shirt. Look around everybody else. Look around. You see ties? The guys have ties on them. Because it's a place of importance, respect, the Constitution, important things. They may not be important to you, but they're important to most people, and they're supposed to be important for everybody. Maybe that's why you're here. The rules aren't important, but you're going to be held accountable because people do think they're important. It's the way we live together peacefully so we can all enjoy the blessings of liberty. All right. What is the issue today?
Pat, you just pulled the second piece of paper you have in there, just so highlighted area.
All right. Did you get a copy of this?
I did, Judge, and I have it in front of me.
All right. Well, it looks like last month a drug patch was collected and showed positive for cocaine as a result of the testing. Okay. Anybody wants to say anything?
Yes, Your Honor. So my client just recently was released on bond, and while he's in the,
When?
I don't remember the exact date.
Let's find the date. Okay. Whatever that is. Anybody know?
I'll look up this.
But while he was in
Let's find the date
yes, sir.
so we can go off some things that are certain.
It was a recent bond. All that show is from 2024.
It
No,
was released February 27th to 26th.
no, a little over a month.
Okay, I see it now.
Yeah.
Okay, go on.
Thank you. So while he was incarcerated, Your Honor, he was on some medication, and then when
Okay.
no,
They had him on cocaine?
no,
Okay.
but it wasn't a medication for mental health. And when he was released, that he didn't realize it was showing up on his drug patch until I notified him. When I was notified,
What
by
was
the court,
showing? The
that
cocaine?
that anything was showing up in his system.
Well, I mean, how's that supposed to be until something is collected and then tested and analyzed and then reports back to us?
Understood. But since then, Your Honor, his drug patch numbers have gone down. The last drug patch showed clean. And immediately when I notified him of the drug patch results, he went and on his own and had a UA and a hair follicle, which he does have with him today, that both showed he was clean. So he did do the best he could to show.
What was the
you.
date of that?
I'm blind, Your Honor. Give me a
That's
second.
okay.
Which one is the hair?
That's
Here's the hair follicle right here. It was collected on April 17th, and the report was issued on April 24th of 2026. Would you like to see it?
No. Your word's good enough for me. But on this collection on March 13th, he had been released from jail.
He had. The same week, he did go take a drug test for employment and passed with flying colors, which is also one of the documents in here. This would be the drug test he took for employment during the time of the patch.
And he had been released from jail when?
February 26th or 27th?
27th, February 27th.
Of 26.
Okay. So how do you explain the positive in March?
He believes it had to do with something that was in the medication he was taking at the jail. There is a log of the medication as well.
That's what he believes
That's
from
what he
his
believes.
medical experience
Yeah,
and
Your Honor.
medical training.
Yes, Your Honor.
Anything from the state?
No, Your Honor, I don't know what medications he's taking and hadn't had a chance to even look and see if anything like that has any false positives.
Here's a list. I don't know if any of that rings a bell for you right away, but that's what he was issued in the jail.
I don't know anything that does test positive as cocaine metabolites, but it's all discontinued.
Here's the problem with all of this is that nobody's given me anything about what he's supposed to be taking, but what he is taking and why. But the fact of the matter is that he tests positive for cocaine. So far, what I've heard, all I've done is open a door for everyone to come out of jail and test positive and say, I want the old Demond Sergeant rule. I may or may not have been given medication. But the point is if I test positive, I'm going to use his rule and presume that it had to be something that the jail gave me, which I don't know and I can't answer to because I don't know what they gave me.
Well,
the problem is that it tests positive. He's going to be held accountable. I can always, he's going to be held accountable. His bond is going to get revoked on this. It's just the way it is. If you want to get some more information, I'll open this door up for another hearing from experts, anybody you want from the jail to revisit this. But unless something else happens, this is the way I'm going to rule. I'm not going to presume that the jail is giving them cocaine so that they can test positive a few weeks afterwards and then claim it's the jail's fault, not mine. Please.
Let's say ibuprofen until I looked it all up.
Apparently,
What's his bonds in each case, please?
Judge, on the assault is $110,000, and on the harassment, it's $40,000.
Okay. You test positive for a controlled substance, cocaine. That's a second-degree felony.
My hair fall.
And your bonds are doubled.
his hair follicle did come back clean.
Let's see, 90 days.
When?
Just April.
A month later, ma'am. Not when this test was taken, a month before.
He did have some employment tests that came back clean the week it was taken. The patch was taken.
I trust these people. That's who we use. People who are, I can hear something. Please leave the room. When you disturb this court, leave the room. Kendall, I'm going to have, yeah. We're doing business here. This isn't a cry fest.
Other way.
Hey, ma'am.
Other way, ma'am.
Ma'am, your outburst just made you in contempt of court, ma'am. You can be placed in jail for up to 6 months. Would you please just be polite? Thank you. That's all we ask of people. Be polite. We're taking care of serious business up here. People don't like what happens, and so they make an outburst. You can everybody know that's the rule. You can be held in contempt of court if you make an outburst and disrupt the proceedings. Please don't do that. I don't want to put people in jail unless they're necessary. I made my ruling. So you had cocaine in your system. It's a scientific test, and the court does not believe the explanations y'all have given. So I'm presuming the test is correct. Your bonds are revoked. You're in jail, and you must have a drug patch if you post your bond. Period. End of ball game. What's next? We set this for trial or what?
Yes, Your Honor.
Is that what we want to do on these?
Well, I haven't had a chance to speak with counsel today on that.
How about an announcement in what, 2 or 3 weeks?
That would be appropriate.
Because maybe something could get disposed of to move him along, get him back on his feet.
He is working or was.
Well, of course, he'd have to, because of this, I mean, we'd have to test him to make sure that he's negative. If something is fashioned to where he would be released.
Yes.
But he's got to pass our drug test to get released. What is his criminal history?
He has no history.
You have no criminal history? Sir?
Misdemeanor.
No, I'm talking about felonies.
No felony.
I've said this for 2 weeks. Sooner, I'm always open for business to try to work this out, especially because he doesn't have a criminal history.
Thank you, Judge.
You know what I mean?
Right.
Okay.
Yeah.
Oh, thanks. Yes, ma'am.
In this hearing, Judge John Stevens was not just looking at a failed drug test, he was thinking about the bigger impact on the courtroom. The defense argued that the defendant later passed clean hair follicle and job drug tests. They also suggested that the positive result might have been caused by medication given in jail. But the judge was concerned about something else. His point was simple: if the court accepts this explanation without strong proof, then in the future, any defendant could blame jail medication after failing a drug test. That's why Judge Stevens kept focusing on scientific testing and accountability. The emotional moment came when there was an outburst in the courtroom. The judge reminded everyone that decisions in court are not based on emotions, but on evidence and proper procedure. In the end, he made it clear that until stronger evidence is provided, the court will rely on the scientific test as the most reliable proof. Do you think the judge made the right decision by revoking the bond based on the cocaine test? Or should the later clean drug tests have created reasonable doubt about the original result?